jurisdiction and civil appeals. The Tamaklo case does not in any way discuss the grant of application for the relief sought in this motion before us. In civil appeals and original jurisdiction matters before this court, there are express provisions to grant the relief sought in this application, and the court may, in appropriate cases, grant such applications in the interest of substantial justice under Rules 15, sub-rule 11, and 51 of the CR 16 of 1966. To accede to this application will be tantamount to expanding the scope of the jurisdiction of review, which jurisdiction is not provided under this court by the rules. We find that our inherent jurisdiction cannot be invoked under the circumstances of the case when the rules of court has made clear provisions in the exercise of our jurisdiction in this matter. We accordingly proceed to dismiss the application.
As the court pleases. We are grateful to the court.
My lords, we are most grateful.
Please, can we take the application for review?
My lords, we have filed an application for review on the 20th of January, and that application is accompanied by an affidavit and also a statement of our case. And we rely on those documents, and we respectfully indicates that the review is in respect of a ruling delivered on the 19th of January, which we have exhibited. That is Exhibit TL1. And our three grounds of review indicate that the court fundamentally erred in regarding CI 99 as rendering Order 42 of CI 47 inapplicable, and thus occasioned a grave miscarriage of justice.
Mr. Tsikata, it's Order 22 rather, please, I think. Order 42.
Rendering Order 22. I'm sorry.
Order 42 is on for review.
No, I was reading Ground A.
Yes, but the Order 42, and we are respectfully drawing your attention to
Order 22. I misread. I misread our own Ground A.
Indeed, the whole of Order 40.
No, Order 22 of. I was reading Ground A, and I'm sorry that I misread our own ground. Order 22 of CI 47. And we're respectfully saying in Ground B that the court fundamentally erred in determining that Rule 69 C4 of CI 91 implies that in determining that Rule 69.4 implies that even amendments are not to be granted. And C, that the court fundamentally erred in failing to appreciate that its discretion ought to be exercised in accordance with Article 296 of the Constitution. My lords, it is our respectful submission that there is nothing whatsoever in CI 99 that renders Order 22 of CI 47 inapplicable. And we would respectfully ask your lordships to take cognizance of this Supreme Court's decision in the Republic versus High Court General Jurisdiction, Accra, ex parte Magna International Transport Limited, applicant, and Ghana Telecommunications Company, interested party. And that is civil motion number J5/66A/2017. A decision of 7th November 2018. And in that decision, your lordships determined that an earlier decision of your lordships, which had indicated that an application for stay of proceedings in a case pending before the Court of Appeal could only be brought before the Court of Appeal. Your lordship decided that that earlier decision in the ex parte Abu Dhabi case was in error, and therefore your lordships made it quite clear that nothing in the amended provision that was being relied on, nothing in that amendment provision constituted a repeal of rights that were in the CI 19. My lords, by parity of reasoning, we are respectfully inviting this court not to proceed in accordance with this earlier ruling, but to review that ruling so as to enable interrogatories, so as to grant leave for interrogatories to be served. And my lords, I respectfully rely particularly on the following passage in the ruling of Justice Bain, where he says that thus rules 21 and 28 of CI 19, which enable the trial court to have the first opportunity to stay proceedings before the appellate court becomes seized of the whole appeal, was just a crystallization of the well-known and time-tested principle and practice. Indeed, in such a situation, it is our considered view that any legislation that seeks to alter the settled practice and the settled principle and practice must be expressed in language on the ground that there is a presumption against implied repeal. My lords, your ruling on the 19th of January involved implying a repeal of Order 22 of CI 47. And this is what your lordship said. We are strictly bound to comply with CI 99, and therefore we will not apply Order 22 of CI 47 of 2004 in this circumstance. We accordingly refuse to grant the application, and same is accordingly dismissed. So your lordships, in effect, were saying that you have CI 99, you are strictly bound to comply with it, and therefore you were not in a position to grant us leave to file those interrogatories. Now, my lords, the provisions in CI 99 regarding timelines for an expeditious hearing nowhere explicitly say that interrogatories cannot be accepted. There's nowhere in those in CI 99. And therefore, your lordships could only be proceeding by way of an implied repeal arising from the timelines provided in CI 99. And we respectfully say that that was a fundamental error. My lords, we rely respectfully on the persuasive authority of the decision of the Nigerian Supreme Court in a case that has been referred to in our jurisdiction as well during the 2013 election petition judgment. That is the case of Abubakar and Ya Adoa. And my lords, for what it is worth, we will respectfully submit a copy of the full judgment in that case in respect of this particular issue to the court. That was a decision of the Supreme Court of Nigeria in 2008, January 2008, and I respectfully refer to a few passages in that ruling, including the following from the lead judgment of Nikki Toby, JSC, Justice of Supreme Court Nikki Toby, where he said, the Court of Appeal, in rejecting the application to administer interrogatories, said that it will impede speedy trial of the case. Courts of law cannot sacrifice the constitutional principle of fair hearing at the altar of speedy hearing of cases, when the content of the speedy hearing is not in consonance with fair hearing in the sense of availing the parties, as in this appeal, the right to administer interrogatories. A party who is entitled to administer interrogatories and is denied that right is denied the right to fair hearing. And when I say that, I'm not oblivious of the law that speedy hearing is one vocal and important aspect of fair hearing. The point I'm struggling to make is that speedy hearing of a case which denies a party access to pre-trial evidence, such as interrogatories, is not fair, as it runs contrary to the constitutional principle of fair hearing. And, my lords, it is further stated in the copy that we'll make available at page 17. It is further stated, I'm in entire agreement with the Court of Appeal when the court held that full opportunity should be given to parties in the interest of justice without due regard to technicalities. Gone are the days when courts of law were only concerned with doing technical and abstract justice based on arid legalism. We are now in days when courts of law do substantial justice in the light of the prevailing circumstances of the case. And on the next page 18 as well, it is stated by His Lordship Justice Toby, I do not agree with learned senior advocate that the Court of Appeal drifted into the realm of sentiments when it held that in a presidential election, every opportunity should be given to parties to ventilate their grievances. The Court of Appeal is very correct. I do not see any sentiment. Now, my lords, these were clear statements of the Supreme Court of Nigeria, which we would submit are of persuasive authority. And at page 22 also, there is a clear statement to the effect in refusing the petitioner's appellant's application, the court below in its ruling of 25th September 07 said, I've listened to the learned senior counsel on all sides, and I thank them for their industry. I'm of the view that the answers being required by interrogatories and particular sorts can easily be obtained from witnesses during the hearing of the petition. In an election matter, anything that will impede speedy trial must be avoided. In the circumstances, I refuse the application and it's hereby dismissed. That was in the lower court. And then the court proceeded. I think with respect that their lordships of the court below were in error on their conclusion. They failed to consider the purpose sought to be achieved by the application for the delivery of interrogatories. There is no doubt that there was the necessity to hear this case expeditiously, but the ends of justice ought not to be sacrificed just because of the desirability to have the case disposed of speedily. And then they continue with a number of sub-points, and then this passage ends. I would like to say here that a more widespread use of interrogatories in our system in Nigeria will in fact aid the speedy dispensation of justice, because answers are delivered by affidavit evidence, which puts the person upon whom they are delivered at the risk of being commuted for perjury if he does not truthfully and fully answer the questions. So, my lords, the clear indications from these passages of the judgment are that, in fact, interrogatories serve the interest of expedition. And I would respectfully submit that that is an important consideration in this case, which we urged before this court in our application for leave. as we clearly indicated, the provision of answers to the interrogatories would facilitate an expeditious trial. We also respectfully wish to draw your attention, your Lordship's attention, to a statement made in the same Nigerian Supreme Court case by His Lordship Justice of the Supreme Court Tabai at page 26 of this report that we will make available. And His Lordship says, I took time to study the 27 of them, that is interrogatories. In my consideration, the answers to these questions are peculiarly within the knowledge of the fifth respondent. Interrogatories and the answers should be put in evidence by the party who wishes to rely on them, and admissions made in a reply to interrogatories are conclusive of the facts admitted. I do not agree with the reasoning of the court below that the answers being sought by the interrogatories can easily be ascertained from witnesses during the hearing of this petition. It is my view that the application with respect to interrogatories was wrongly refused. It ought to have been allowed. And finally, my lords, in this and this is at page 30, where again it is stated that this procedure will certainly narrow down the issues in controversy and will facilitate the quick and early disposal of the petition. It is not a novel practice. So, my lords, our submission is that there is no repeal in CI 99 of Order 22, and we would respectfully invite your lordships to be guided by the wisdom of the Nigerian Supreme Court and its various judges in its consideration of interrogatories. I would also respectfully refer your lordships to the work of Justice Marfo Sang, A Practical Guide to Civil Procedure in Ghana, in which at page 107, actually I think those were in the days before he became a lordship, but at that page 107, and his lordship adverts to the use of interrogatories and provides a piece of practical wisdom that we have been guided by in our preparations for this petition. He says that the answers to the interrogatories, which are formulated in the form of an affidavit, may be put in evidence by a party at the trial of the action. Now, my lords will notice that in the witness statement that we have filed, in one of the two witness statements, the witness actually makes reference to the fact that we have filed not only the leave for interrogatories, but we also filed a request to admit facts, all of which are within these pre-trial processes. And in the case of the interrogatories, if leave were granted and those answers were available, then as Mr. Marfo Sang, as he then was.
No, I think it was in the Court of Appeal.
As a writer,
Exactly. So the indication that has been given in that witness statement is that we would expect that the answers to those interrogatories would be available to put in evidence, which will then limit the scope of controversy, and therefore it would limit any additional recourse to oral testimony or to testimony that would be regarded as controversial, because it would be in evidence in a manner which is regarded as uncontested. My lords will also appreciate that in respect of the matter concerning the request to admit facts, which is not an issue in this review, but I'm just drawing attention to it in the context of how we believe that these pretrial processes actually aid to achieve expeditious justice. Because essentially, both the responses to the interrogatories and the responses to the request to admit facts narrow down the issues. And it is as a consequence of that, for instance, that we are now in a position, instead of having 5 witnesses, to limit ourselves to 2 witnesses. Because the request to admit facts, for instance, within the 14 days that those facts are requested after the 14 days, if they are not admitted, they are taken, if they are not answered, they are taken as admitted. So we are making a search to determine when it was served on them, and then we will be able to seek leave, if need be, for a supplement to the statement, to the witness statement, which would then enable that to be in evidence. So, my Lord, we are grateful to Mr. Malfo Sao for those words of practical guidance in his treatise on a practical guide to civil procedure in Ghana. Now, we respectfully submit that the same approach of this court in Republic and High Court Ex parte Magna International Transport, that same approach is found in this court's decision in Mona and the Attorney General. Where again, that is 2013 Supreme Court of Ghana Law Report, page 502. That court was faced with an issue arising from an amendment to Rule 55. And that amendment was by reference to Rule 71B in CI 74. And as it turned out in that case, Rule 71B actually had a heading, no review, suggesting that it was purposing to prevent reviews. And this is what their lordships concluded. And I refer to the judgment of Justice of the Supreme Court Benin at page 512. Thus, when the Rules of Court Committee was charged under Article 64(3) of the Constitution with the responsibility of enacting rules to regulate the conduct of the practice and procedure in presidential election petitions, it meant the substantive laws were different from what the committee was empowered to do. The committee was not empowered to amend the substantive law without express authorization. One such substantive law in place is the right of review given to the Supreme Court by virtue of Article 33(1) of the 1992 Constitution. Review is not a matter of mere procedure, but an important and substantial constitutional right. Any attempt to alter the right of review will be ultra vires the functions of the Rules of Court Committee. And any attempt to remove the Supreme Court's review jurisdiction or a party's right to apply for review, except through an amendment following due procedure under the 1992 Constitution, will be unconstitutional. Now, our argument is by parity of reasoning. We're not saying that exactly the same circumstances are here. We're saying that by parity of reasoning, if there were intended to be a repeal of a well-established process, such as the pre-trial process of interrogatories being filed or other discovery processes, if there were an intent to do that in CI 99, it would have had to be very express in order to achieve that result. That result cannot be achieved by means of an implication being drawn that the timelines do not allow for that.
Mr. Tsikata?
Yes.
Is there a difference between a constitutional provision that is impliedly taken away because of CI and a provision that is resorted to in order to do justice? Is there a difference? I'm thinking of your parity of reasoning, and I'm wondering why you would compare apples and oranges in that way.
My lady, as I indicated, we are not suggesting that they're exactly the same circumstances. But in each case, in the case of the ex parte Magna authority, which says that there can't be an implied repeal, in the case of the Bernard Mona situation, which says that a rule of the Rules of Court Committee cannot take away a constitutional right. In each case, we are talking about an existing right, an existing practice and procedure. If it is being sought to be taken away, one, as ex parte Magna says, it has to be explicit. It can't be done by implication. And two, in the case of the constitutional situation, the position is that it cannot even happen at all. So that is in extremis. That is in extremis where it is simply impossible. But I'm saying that...
That is why I'm wondering why you would compare a situation in extremis with the situation that you are talking about and reasoning that by parity of reasoning. That's what I'm referring to.
Because in principle, in both cases, you do not have an express repeal of an earlier CI. You do not. In both cases, there isn't. In fact, that is why in the Bernard Mona case, even though the Rules of Court Committee may have thought that they were taking away the power of review and they put no review at the top, even though they put that, the court decided that it did not have that effect. Because looking at, and my Lord, again, this is a matter of looking at the language. The Bernard Mona decision is absolutely on all fours because the court looked at the terms of the amendment. The terms of the amendment showed clearly that it was not seeking to review. I'm sorry, it was not seeking to take away the power of review. The terms, and we are saying respectfully that the terms of CI 99, nowhere do the terms of CI 99 seek to take away the power to have interrogatories served in Order 22. So there is a clear parallel because the court is saying, let us look at what the so-called amendment is trying to do. Let's not even bother with the heading. The people in the Rules of Court Committee may have thought that they were taking away the right of review. But let us look at the words. And those words did not indicate that the right of review was being taken away. In the same way, we are respectfully saying to your lordships that the words in CI 99 nowhere say that they are taking away the powers under Order 22 of CI 47. Nowhere. And I would respectfully challenge anyone to point to any provision in CI 99 that seeks to take away what is provided for in Order 22 of CI 47. And my lords, we would respectfully also draw your attention to the provision in Article 1294 of the Constitution, which states that for the purposes of hearing and determining a matter within its jurisdiction, and the amendment, execution, or the enforcement of a judgment or order made on any matter, and for the purposes of any other authority, expressly or by necessary implication, given to the Supreme Court by this Constitution or any other law, the Supreme Court shall have all the powers, authority, and jurisdiction vested in any court established by this Constitution or any other law. So it is without a shadow of doubt that those provisions in CI 47, Order 22, in respect of pretrial procedures, those provisions are available to the Supreme Court. And it is on the basis of those provisions that the Supreme Court in 2013, in a petition brought by Nana Addo Dankwa Akufo-Addo, had recourse to Order 22 of CI 47. Our submission is that it cannot be that just because this petition is by John Dramani Mahama, it cannot be that it cannot be.
Mr. Tsikata, please, let's try to.
My Lord,
it's okay.
Respectfully, my argument is that there cannot be a different interpretation of the law.
With due respect, if the 2013 case is cited, then it will be clear to all of us. That's my worry. What I'm saying is that if it is a reported matter, yes, if it is cited in course of arguments, yes, that would be the appropriate thing.
Mr. Tsikata, and additionally, the 2013 election petition was not done under CI 99. So that is the change, rather than the personalities involved. I think you.
Yes, my lords. My lords, I believe I have indicated that nothing, that's my first argument, nothing in CI 99 took away that authority. I've indicated that. And therefore, and building on that, I'm saying that it cannot be any different from one petitioner as against the other. We'll leave out the names of individual petitioners, but it cannot be different as between one petitioner
Mr. Tsikata,
or the other.
Can you explain to me how come the Rules of Court Committee was seized of this matter after 2013 and still did not make this provision?
And so what?
And still did not make this specific provision that you are saying somebody benefited from, and so everybody must benefit from. How come the Rules of Court Committee had another opportunity to make rules and did not say anything about it?
My lords, as I've indicated in answer to your previous question, I frankly have no knowledge of the deliberations of the Rules of Court Committee, and I'm not, with respect, willing to go on an expedition into the minds of the membership of the Rules of Court Committee as to how come they did this or they didn't do that. That, respectfully, is completely outside my terrain. What is within my terrain is what they have provided in CI 99. And in CI 99, nowhere do they say Order 22 is repealed. Nowhere.
CI 99 has repealed Order 40, Order 22, or CI 47. We just said that. You just read the ruling, the basis of your Grant A. We are strictly bound to comply with CI 99, and therefore we will not apply Order 22 of CI 47 of 2004. We did not say CI 99 has expressly or impliedly revoked or repealed Order 22.
Yes, but
Mr. Tsikata,
yes.
If you allow me to lie, we're just saying that we cannot apply, in the circumstance of this case, we cannot apply Order 22 on interrogatories. That is all that we said.
Yes.
We never alluded that CI 47 Order 22 has been amended or repealed.
Yes, but my lord, with the greatest respect, if the circumstances are no different,
Yeah.
My lord, may I finish my sentence? If the circumstances are no different, except for the fact that there is now CI 99 providing a certain timeline for decision making, we are submitting that Order 22 is still capable of being operated within the timelines that are given in CI 99. Nothing stops Order 22 from being implemented and the timelines not being complied with. Nothing.
If you note, the very first reason in the ruling of the court is that the crucial issue of relevance has not been established in the petition. That was the very first reason.
And that crucial issue of relevancy is referred in the ruling paragraph, the sentence just before that. Interrogatories under common law is discretionary. It should be granted or refused. Interrogatories under common law. We did not seek interrogatories under common law. We are seeking interrogatories under Order 22 of CI 47. And we are saying with respect, that if it is a question of relevancy, I mean, respectfully, if it is a question of relevancy we are talking about, how can it not be relevant that an interrogatory that seeks to ask, for instance, question 7, when did Mrs. Jean Adukoya Mensah the chairperson of first respondent and the returning officer for the presidential election first realized there were errors in figures she announced in her declaration of 9 December 2020. 8. How did Mrs. Jane Adukwe-Mensah, the chairperson of first respondent and the returning officer for the presidential election, get to realize there were errors in figures she announced in her declaration of 9 December? 9. In respect of the purported corrections made to the figures in the declaration by first defendant, was there any prior process of conferring with agents of the presidential candidates? 10. Did Mrs. Jane Adukwe-Mensah, the chairperson, present Form 13 to all the agents of the presidential candidates to sign? And if so, did all the agents sign? 11. On which date did Mrs. Jane Adukwe-Mensah, the chairperson of the first respondent, post a copy of the Form 13 at the head office of the first respondent? 12. Did the first respondent record any discrepancies which were occasioned by computational and mathematical errors in the course of the collation of the result? How can it possibly be said that none of those questions, just to give examples, none of those questions is relevant to the determination of the suit? A suit in which...
Mr. Tsikata, I hope you are not saying that those kinds of questions cannot be asked in cross-examination.
My lords, we have never said those kinds of questions cannot be asked in cross-examination. In fact, when it was suggested by counsel on the other side during the hearing of the application for leave that they can be asked by means of cross-examination, we made it quite clear that in fact, being able to have those questions addressed in interrogatories saves time, because then you don't have to go into them in cross-examination. Why would I spend, questions in cross-examination dealing with something that has already been answered on oath? That is why we say that we have been practically guided by that wisdom that if it is stated on oath, we put it in as evidence, so we don't need to cross-examine about it because it's already been determined on oath. So why would we go into cross-examination? I fail to see how it does not expedite justice to have the matter answered in an interrogatory rather than wait for cross-examination to do that. And the reason I respectfully say that we are guided by the practical wisdom in Mr. Mafusau's book is that if you prepare your case, part of the preparation is anticipating what you might do in the examination in chief of your own witnesses and what you might wait to do in cross-examination. But in preparing our case, we thought it important to have those questions dealt with in interrogatories so that we would not be burdened to have to ask them subsequently in cross-examination. In any case, your ladyship, if the questions are not relevant, how can they be allowed in cross-examination if that is the position? If the questions are not relevant, if that is the position that's been taken, then they cannot be asked in cross-examination either.
Are you attempting to cross a bridge you have not reached?
Well, I believe you put that bridge there. Your ladyship put that bridge there. And therefore, I had to deal with that bridge. Your ladyship raised the issue of whether it can be raised in cross-examination. And, respectfully, part of the reason why we cannot wait for that bridge in the preparation of our case is that in putting forward our case, we absolutely need that evidence. It is material to our case. And we need that evidence so that we can put it in as part of our affidavit, as part of our witness statement. And we respectfully ask your lordships to grant the relief. Indeed, my lords, as we indicate in our grounds B and ground C, the ruling also claims that...
Counsel, please, I think some of these submissions are captured in the statement of case.
Yes,
if you can highlight on some of them so that you wind up. Yes.
I'm winding
Okay.
up. I'm winding up. But I also had to respond to the questions of your lordships. My lords will see that it is stated that Rule 69C4 not only sets timelines, but it implies, and these are the words in the ruling, it implies that even amendments ought not to be sought and granted as well as joinder of parties. Now, my lord, so this is the legal basis on which that exercise of discretionary power is being exercised, that even amendments ought not to be sought and granted as well as joinder of parties. We are saying with the greatest respect that that is a fundamental error of law. Nowhere in CI 99 does it say that amendments ought not to be sought and granted simpliciter. Nowhere. No.
In any case, we granted an amendment.
I'm sorry.
We have granted an amendment in this case to the petitioner.
Because it is allowed in the rules.
So that is not what we meant.
Well, but that's what is stated. In the ruling. It says it implies
the rule does not allow amendments, substantive amendments to the grounds.
My lord, I just read from the ruling. There's no qualification.
Yes, but that is not. That is just as you said. You can't go into our minds. You can't go into the minds of the rules of court committee members.
But we can go into the letter of your ruling.
Yes, so that is not what we meant. That the rules does not allow substantive amendments to grounds and all that. Other than that, would we have granted you the amendment that you sought?
My lord, at a minimum, what your lordship just said suggests that your lordship should, at a minimum, review your ruling so as to qualify the reference to amendments appropriately. Because we expect nobody reading the ruling that you've given can see the word substantial in that. Nobody can see that. And in any case, in CI 99 does not, my lord, with respect, I leave my submission at the point that that statement, as it stands in the ruling, is not borne out by CI 99. I leave it at that, and it is obviously up to your lordships to determine ultimately whether indeed Rule 69(4) says or implies that even amendments ought not to be sought. My lord, with respect, I mean, the amendment that we sought and that was granted, I mean, was a very insubstantial and frankly a clerical error which was corrected. That should not be touted as a reason for somehow not accepting the argument that we are making. My lord, my final submission is that this court fundamentally erred in failing to appreciate that its discretion ought to be exercised in accordance with Article 296 of the Constitution. And that Article 296 makes it clear that where in this Constitution or in any other law discretionary power is vested in any person or authority, that discretionary power shall be deemed to imply a duty to be fair and candid. B, the exercise of the discretionary power shall not be arbitrary, capricious, or biased either by resentment, prejudice, or personal dislike, and shall be in accordance with due process of law. We are respectfully submitting that in respect of your discretionary power to grant leave for interrogatories, there was, with respect, a duty to be fair and candid, and not to act in a manner that is arbitrary or capricious. And our respectful submission is quite straightforward in this regard. Our respectful submission is that in terms of even a determination about the relevancy of the interrogatories as we had drafted them and the questions, in terms of a determination of relevancy, your lordship should at least have considered the terms of the questions posed in the interrogatories by reference to the issues in this case. Because if your lordships had made that reference to the issues in this case and to the questions that we have posed, with the greatest respect, it would be perfectly obvious that those questions were legitimate questions that required answers to be provided. So it is not sufficient just in one fell swoop for it to be said that the crucial issue of relevancy has not been established. With the greatest respect, it is not. It is not an exercise of discretionary power consistent with Article 296 for there to be such a disregard of the terms of our interrogatory.
My lords, we are opposed to this application for review, and we rely on the depositions in the affidavit in opposition and the statement of case that we filed. My lords, under CI 16, Rule 54, the court may review any decision made or given by it on any of the following grounds: exceptional circumstances which have resulted in miscarriage of justice, or discovery of new and important matter or evidence which, after the exercise of due diligence, was not within the applicant's knowledge or could not have been produced by him at the time when the decision was given. My lords, the submissions that we have heard today have not canvassed any new matter or exceptional circumstances for which this court review jurisdiction should be exercised. My lords, what we have rather heard was a rehashing of the arguments that was before the court when the decision was taken on the 19th of January. In this regard, my lords, may I humbly read the decision of Adade GSC in the case of Mechanical Lloyd Assembly Plant versus Nati, reported in 1987-88, 2 Ghana Law Report 598, Supreme Court. My lords, with your kind permission, it says, let me say at once that for all I know, virtually every judgment on this earth arrived at as a result of evidence gathered from several sources can be criticized. A Privy Council judgment put in the hands of any lawyer along with the evidence grounding it can be criticized in the same way as a High Court judgment can be. A person who has lost a case will almost instinctively feel that the judgment must be wrong. And why not? If he had won, the decision will be right. So if he lost, how could the court be right? But the mere fact that a judgment can be criticized is no ground for asking that it should be reviewed. A review jurisdiction is a special jurisdiction to be exercised in the exceptional circumstances. It is not an appellate jurisdiction. It is a kind of jurisdiction held in reserve to be prayed in aid in the exceptional situation where a fundamental and basic error may have inadvertently been committed by the court, which error must have occasioned a gross miscarriage of justice. The review jurisdiction is not intended as a try-on by a party after losing an appeal, nor as an automatic step from an appeal. Neither is it meant to be resorted to as an emotional reaction to an unfavorable judgment. My lords, it's my submission that the arguments we have heard today by the applicant is just an emotional reaction to an unfavorable judgment quoting Adade, and therefore this application should be dismissed. That's my submission.
My lords, we are opposed to this application, and we rely on the depositions in our affidavit in opposition filed on the 25th of January 2021 and our statement of case filed on the same day. My lords, we wish to make the point from the very beginning that the court grounded its dismissal of the application for interrogatories on 3 key points, and not as counsel for the petitioner has sought to suggest on 1 point. The court raised the issue of relevancy, the issue of lack of matters in controversy, and then made the point, the 3rd point, that CI 99 establishes strict timelines, and therefore the application will not, therefore Order 22 will not apply in this circumstance. So the first myth that has to be blown away is that the court never ever said or implied that CI 47 had been repealed or will never apply in a petition, in an election petition. This is a gross misconstruction.
He said Order 22. Order 22.
Yes, Order 22 or CI 40. I mean, I'm saying that my submission is that this interpretation is a gross misconstruction and an impermissible gloss that counsel seeks to put on what the court said. Now, my lords, my second point here is counsel has raised the issue of relevancy. Now, the issue of relevancy goes to the issues to be determined in the trial. And if your lordships look at the issues to be determined in trial as set out, it becomes very apparent that these matters that were raised in the interrogatories are not really germane to the issues to be determined in trial. The issues are, one, whether or not the petition discloses any reasonable course of action. Two, whether or not, based on the data contained in the declaration of the first respondent and the second respondent as president-elect, no candidate obtained more than 50% of the valid votes, as required by Article 63(3) of the Constitution. Three, whether or not the second respondent still met Article 63(3) of the 1992 Constitution threshold by the exclusion or inclusion of Techiman South constituency presidential election results. Four, whether or not the declaration by first respondent dated 9 December 2020 of the results of the presidential elections conducted on 7 December 2020 was in violation of Article 63(3) of the Constitution. And finally, whether or not the alleged vote padding and other errors complained of by the petitioner affected the outcome of the presidential election. My lords, it is my submission that it is more than obvious that the issues sought in the interrogatories, are not really relevant in the determination of these matters. Secondly, my lord, the court's second reason was that the issues sought in the interrogatories were not related to issues in controversy. That is, the issues joined by the pleadings. It is then only after these two fundamental reasons that the court makes the observation that in any case, or in addition, CI 99 prescribes strict timelines. Therefore, the court will not apply Order 23. In this circumstance, what is meant by this circumstance? That is, all the issues that have been looked at or discussed in the ruling. We all know that when you are doing interpretation, you do not just pick one sentence or paragraph out of a whole construction and make a meal out of it, as counsel for applicant seeks to do. My lords, let me then make the point that the reference to the Mona case, my lord, is misconceived and involves a deliberate attempt to put an impermissible spin on the Mona case for purposes of this application. In the Mona case, what the court held was that rule in CI 74 that sought to take away the right of review was unconstitutional. Now, in order that the petitioner can suggest the relevance of the Mona case to the present application, he seeks to suggest that the CR 99 has impliedly repealed the right to interrogatories. That is the whole point. Now, if the court, as I've demonstrated, has nowhere said that CI 99 has repealed or amended the right to apply for interrogatories under Order 22. The whole argument of the relevance of the Mona decision falls flat. It crumbles, my lord. Now, similarly, my lords, we believe that it is important to recognize the point that every application that is brought for interrogatories must be decided on its own terms based on the general principles governing the grant of application for interrogatories. Therefore, it is again misconceived for counsel to suggest that because in 2013 an application for interrogatories were granted, automatically the Supreme Court is bound any time an application for interrogatories is brought in an election petition to grant it. My lord, that is poor logic.
We are used to our jargons. Maybe you can say that it's misconceived.
Very well, my lord.
Yeah, we are used to our jargons. We are
my lord,
other professions.
My lord,
yeah.
My lord is well taken.
Yeah.
I withdraw that point. But my lord, I believe that it is completely misconceived to suggest that because in 2013 we were granted interrogatories, in this case we should be granted interrogatories. Again, the lords, my lords, I want to refer to the Nigerian decisions. My lords, and all the other decisions that were referred to in paragraphs 23, 25, and 26 or so of the statement of case. My lords, in all those decisions, the court, exercising its discretion, held that in the particular situation, the applicant was entitled to the grant of interrogatories, and therefore held that the refusal was wrong. So, my God, lords, one cannot just cite those examples to determine that the refusal in this particular case was wrong. Again, the applicant has the burden of demonstrating to the court how the refusal in this particular case was wrong. And furthermore, he has an obligation to demonstrate, one, that the error was a fundamental error, two, that fundamental error occasioned them a gross miscarriage of justice. My lords, it's our submission that the applicant has failed to demonstrate these very basic conditions to grant a review. In the circumstances, my lords, we pray that the application be dismissed as completely unmeritorious. Pray accordingly.
My lords, yes, respectfully.
Because I think as regards the first respondents, the opposition, he just cited the off-putted
which made reference to the mechanical Lloyd case. Because, my Lord, I think it's important to...
Yeah, what is the case?
This is Hannah Asi, number 2. Hannah Asi, number 2, and Gihok Refrigeration. 2007 to 2008.
Yeah.
Supreme Court of Ghana Law Reports at page 16, which actually, it considers all the line of cases.
I think it was referred to.
My Lord, it was not in our statement of case.
Yeah, it is.
My Lord, I think you're referring to the draft of our supplements to the statement of case, which your lordships have thrown out of the window.
I wouldn't like Mr. Kutampao to use certain words in the court of law, so please, without...
With respect, I didn't say that disrespectfully. I use that word out of the window in a light-hearted manner, but if it's offensive, I take it back. I use that word just in a sort of light-hearted manner of, so I take that back as not reflecting perhaps the circumstances here. So I was simply drawing attention to the fact that Hannah Asi is not in our statement of case. That's all. Yeah. And I would also respectfully, in relation to the point that counsel for the second respondent made about the exercise of discretionary power, I would also respectfully refer your lordships to another authority of the Supreme Court. In the case TDC and Musa against Atta Bafo, TDC and Musa against Atta Bafo. That is 2005 to 2006, Supreme Court of Ghana Law Reports, page 121. And in particular, His Lordship Dr. Barnes' words at pages 152 to 3. Now, my lords, you also heard counsel for the second respondent suggest that the issues that you have set down are the basis on which relevancy must be determined. With all respect, those issues that you set down were actually set down after the hearing of the application for leave. After. So, unless my learned friend was anticipating that those were the issues that would be set down, respectfully, those at the time of our application for leave, those issues had not been set down, and therefore it's illegitimate for him to claim that it is in terms of that application for leave that he's arguing. And finally, my lords, the reference that is consistently being made to strict timelines under CI 99, respectfully, my lords, we are saying that what the application sought to do was actually to facilitate those timelines, especially in terms of a judgment by March being complied with, because we're not waiting for things to be done in cross-examination and so on. And my lord, if you wanted to be literal and mechanical about the meaning of those timelines, we would draw your lordship's attention to one very simple example. The timelines put filing and serving of process of the petition in January, for instance. January is stated in CI 99, Rule 69C4. It says January, filing and service. Are your lordships going to say that because we filed on the 30th of December, and the process was served by the 31st of December, therefore we do not comply with the strict timelines in CI 99? Are your lordships going to say that? I mean, with respect, this very simple way of trying to interpret Rule 69C4 would lead to gross absurdity if we were to follow it.
All right. Order, please, order.
Abusia yadamase se fidie no eguso a Adom TV so na wo hwe yen Adom FM so edem na Asempa FM Nhia FM ni nyina ya fimpinu ne aduonu abacho akiri omeya se nibia kese ya asem akoto wopono so ye wo so wo hwe na wo hwehwe adwen efa ho ene lawyer Tsikata eye na de se de ye de to mpanimfo anim ema mpanimfo ye se wabo de agu eye review no eno ho ensem na nei sempenimfo beji atum sempenimfo enye entum ye ma ho kwan no ho nsem ene oguso a wo hwehwe adwen mo na ansa na ye beba review no ensem so no abusia wunim se lawyer Tsikata ensem a ene wode etopono so adesede ye a wode etu dwa no wodi kan ede adesede ye supplementary statement ho adesede etompenimfo anim se nke ye ma ne kwan na chese nka wonfa ensem ba ko mienu bi nka ne ensem a edika betodwa ndie empanimfo ni nyina asi adwa no wabagu nti se ni aka eye review no se empanimfo ebehwe aye ho adwuma na se wonye ho adwuma no eno so na oguso a wo hwehwe adwen ewo ho kwadwo empempenso aye duro
no on se kana nka se na ni ma mienu na nanka edapono so a ombe timi atie firi ho nanka wadi wani akyere asem na nkasa so na edi kan no eye sa review application a oyeye na efa interrogatories no no na de tosu mienu no eye stay of proceedings no ti weni ni ma mienu na omde sa supplementary application to amend the 28 no
yeah paragraph 28
no on statement no na omde eno aba omo
and there's somebody can
any grounds here hence no omaye fro they say no ni yabaso no review no ankasa omo ehwe anaso wo sre court no say court no besa mo akwanya na ensem maako dumienu bi a okruchi egu krata so a kopese electoral commission eba obebusebusa no sansem no na ketimi aboa on na wanya wasem no nyina ne tofabo na nka wode akọ wogiri se no ne beti ama eye asem no wadi ni tie asena nka wawie na court eka se sada no wo se enya de a ensem wo kan no etosumu enya de a efa amremu na impo no hwe a ewo common law mu na nkasa no eya de a se judge pa eno betimi di amount
na asembisa no sokra no eba main case na nkasa obetumi ebisa no ewo ho no
ha nteno no medi nyina so a omo edismiss say no ena wo pe review ni no nti enei eno na ye hwe sese no omo aka na edi kan no awie wapie okọ twintonto anase wokọ abrewanim na wakotie ni abrewati abeka na omo edi aba
omasan ba bio ye beba so na ade ba kwa wo hwa lawyer Tsikata eda empanimfo etena asem so ka say ya bo agu ode ne request ne betu dwa waka beto sabre eye se mayen kase ye nibre ena duana mienu na wo se adidi asem no na nti ye pentem na asɛmie no yɛayɛ ne ntɛntɛm so a yɛmma ho kwan ma obi asɛm a ɛwɔ sɛ ɔka wɔnka yɛbɛka obi kasaboa ahyɛ wohwɛ a ɛnɛ wasan atimu hɔ no mu bio akyerɛ mu sɛ naano ne statement ɔyɛɛyɛ sɛ yɛnhwɛ na yɛanka sɛ ɛbere nti yɛ asɛm no no kredie baabi a wɔsɛ biribi atɔ no yɛtumi de ato hɔ ɛnɛ so wasan si so na kwadwo ansa na abɛba anum no abusuafo yɛde asedama enwuma yɛ ta yɛkyi ɛwɔ dwumadi a yɛde ɛba yi mu fam wo yɛ de gu kai mu deɛ sɛ abusua wo pɛnnɛ ne yɛ wɔ dwa so a ɛyɛ petrosol mpanimfo se yɛma wɔ maneɛ sɛ kaa no sɛ woanhwɛ ye na yɛka wantie kɔtɔ fam wo bi akɔgu mu a w'ani bɛba ahosuo no na kaa wo kaa ntutuo nko a wotu kaa no baabi a ɛnyɛ ye petrosol ɛboɔ no ɛda fam wɔnye kɛse biara o wotɔ wɔ fam mu no so a quality no wɔdwene ho ɛna ɛboɔ no so ɛda fam eti sɛ wobɛtɔ fam wo de agu kaa mu deɛ a kae na hu sɛ ɛyɛ petrosol ɛna ɛwɔ so dwen quality ho na tɔ fam wo papa egu wo kae mu panimfo baabi a wonam biara no hu sɛ yɛatwerɛ petrosol hɔ no ma na ɛsɛ ne papa no DBS adaroma wobɔ wo dan so a ɛnkyɛnse papa a yɛde bɔ da so DBS roofing sheet DBS nkyɛnse ɔde abɛdwa so neɛ yɛwɔ ho nie ɛnɛ wonum ko a na akyerɛ sɛ yɛbɔ da so a sɛ nye nnua ɛna yɛde bɔ da so bio dadeɛ ɛna wode bɔ da no so eti nkankanwe nkyɛnse so ade bɔ da no so no awiabɔ a ɛkyi heat no heat megina wo dem hɔ no mo ɛkyi heat no nti wanhwɛ yikura air condition kura wo hia bi wɔ dem so you see DBS roofing sheet a de ɛwɔ mu no ɛna nkyɛnse no so wɔgye wɔ ho die nti ɔde ma wa 20 years warranty ne yɛde ata wachi afebɔ kala wopɛ ɛna wo gye ama eniema etumi akoye ɛde ama kama na abusua esi mustu immune system no sɛ wo boostu a yɛbɔ nuro bi a Food and Drugs Authority mpanimfo ahyɛ da hwehwɛ mu agye atum Ghana fo so ahwɛ kasa duro yi ɛyɛ emu baako ɛyɛ koa mixture abusua wɔnsɛ mabodin no mienu miensa na ɛkyɛ koa mixture sɛ duro yi wonom a enkwam waye wo nipadua no mu no ema hode bam eti sɛ yade bia bɛbɛ nipadua no mu a na bɔ na tonkyɛn sɛ yade bia ekwan krokro ahyɛ wo mu a koa mixture ehu asɛm dɔso wo de wo kɔ baabi ɛtɔ ne adura na obisa koa mixture wo benya bi atɔ ha bia ne akyire abibiduro krogen ɛne yɛde ayakeka nneɛma bom ne yɛde abadwa so abusua yɛbɛkɔ homa so yɛnsɛntwɛni kwadwo mensa abrampa ɛne ɔwɔ court hɔ no mo say COVID-19 say akatakati anim when eba for man watwe aba soro yenko kwadwo mensa abrampa ewa homa so yene no entwetwe nkomo hello kwadwo
watwa
ya san sorry bio na de ye sorry akwa aba no je beba mpa aha ise se wo hwe lawyer Tsikata ahoboabo a waye akinye no je se wakuruchi no wo yugu nti yenhwe ne asie bone tofama yen
Every what we have to do, Mama, I shall for Warrior, never you or Adom FM. Evaka, I'd appended to me, which I Tsikata, the two, I get the phone in there. It's a 1 more, 1 or 12 interrogatory should be up there. Issue, boss, Jim Mensa, Oberans, and was it also there, sir, boy, the man, on Bob Wa, my sins, you know, according to them, and there. The same was, I watch after there will be so discerning some, but I will be another Cabanimuna. When you're done, I mean, you say, share on Bob Wa, ma, sir, will be another Cabanimua, on sending this and the medium. And the interrogatory now work out and capot when I'm 1 year no. Court book with 1 other 7 quick. Until I'm doing our file application for review. On internet, that's not what a panel, I don't know what now on. No, yeah, 7 in some this year, Wabaya, I 9. It's under what the Nipa being Wabaka 7 9 or no. Ama, what is a review? See, over at Tsikata, Asan Edian and Nada, or Chile Supreme Court, I get the same. Central there. Then review now what I interrogatories no what grant now on this decide the mention some into no Nkubona Oboy Nkruno Chirima to there say Supreme Court painful there was a CI99 legal guarantee 1 month an interrogatories and bada not there 1 month a Panama then one got over there some no according to them. Oh, my Panama, according to them, into a total sound there. one boy and Nanka, one mother Mukan, and one man with a Mukanina, a room of one of us had no bishop and some non so boy, a man, some was able to be got to know if you move up and now, za, at and 10 hours panel, once I can. Until it on a Okoti and some Supreme Court will be the Dawa, one of the Mukano da, BBC Kana, woman be ma, Opaka there, 2013, 2012-2013 petition or Beno. I'm paying up for the Kano candidate for MPP or the debate. Supreme Court was 20 until today will be the Abba, Fanama, or Zaba, one pedal, and I do not. I am a Hammond in one pedal of Baja to Manana. I know 1 year Supreme Court paying for the Doma, but what can I do today? And yet, now, Namboom said, of a dog cassa, on for a some no, na nye do baba bodin there oya Muhammad na won pede oba die tum anado ya akofo de ti na wo pede waji tum nti wo ko do san ko Nigeria kra ko fa case bi wo ho o de be share na yam fatu de se shoda no sem na no we no no ye election petition ni bia assassin na what na one man kwan etili review no o man kwan ma oba do nti o sere de ka wo man kwan na wenzi de me asem no na onoka na asem ni obo nu kredi ya na owura wa fra no Justin Amanu bo ye EC one lawyer letter commission lawyer sorry na zitu ngade se asem of the Tsikata oliki odi tuma onye ono wanjun tumu de Supreme Court on grant review esa and asem no wa bogu omo Tsikata oho no wan se na wan kan na zitu ngade se owura Tsikata tamno kana dem was the emotion atunka bi no very can azoke can dimension no sunday want to share embrem potin there the moon day na migina din na wo there wo ma madam kwani na wo ye review o san there morikin ya atunka no very can emotions na amade de no wa gina sam no wa dia tu nti onu ka say wie na mtsewa mpeni akufa do na aloya akotampa on so no ze tu bare second church mo wo Tsikata da bana ete dan ban dan no tunya the man o church ni or chia o church mu no ikano so namdo o church nze me mu tu gade ze esem wore kana ade ingina bibia ni esan de za o cha Tsikata be kan ya Supreme Court wo bogu no ana na wasan we siesie mfufura o kana aka nti o yeda man na mbe na wore hye nti Supreme Court ingina be na asam no na won bongu ono no we cha Tsikata sambe na o be church mu ma wore kan ya da mu no si esan do no wa sampa nti jaji so wan hye na wanka the man no man da na konya na obotu mo nti isi boss den mensa we be sebisa na sam no no bobo ha ma ona asama wo ezi no akọ yi nti ono no hu why na ona mdo ma Supreme Court ba so kru no se woye 9 but wa sola wo tweet na no akwhwe nsam na wo ta Tsikata da tugwa ana za wo Justin Amanu oza tugwa na oru akutampa waza tugwa no odini na bobu hu na wahwede enzi na won fan tugwa eda de oba grant review no ana de oba na bobu tudama ashatu no wode na wo bobu nti ono ho nti na waso
yo kwajo me na wase na yemfa usie da se papa nti omoba ya na chese ya san akaja tummo ene adwuma ye obi oso obi eye busia yensentwe ni kwajo mensa brampa ena yatene ne yeguso ade yaseda ema enwuma ebo ye chido medical de atwo wanim DBS roofing sheet in chance a ye de border so location no anasa hwehwe wachi akwan a chance papa wo de border no so a ensuo beto ehum betu awia bebo oda wada wonu mo Spinters Road wone papaya restaurant na ena edi enihwe e was Spinters Road number betumi afre wo so no eye 0240 844 444 0240 844 444 and I say 054 3286 637 ofra ya estimate kura ye be ya ma free umpewe na peden DBS say ene won enhwimom medical so amatiefo yenyina yenyanentie say lawyer ka ye ho na nedwumade ye de brɛ lawyer nana agei bafo wo zoom ye ne no ebetwetwen enkomo mini abema listo wo kwadwofodwo so wo fie ha na mesumi din akua boachewa yi Adom frɛ me ABY majo so yɛdan yɛ ho abasisi ɛba ya ne yɛne lawyer ɛne kwadwo yɛahwɛ nsɛm a apie mu deɛ kwadwo de ato yɛn Yeguso ewo Adom TV so afimpinu ene aduonu abacho echi semeda omeya se nibia kese Supreme Court eno a ene wani ene waso eguso wo hwe Adom TV live dia na chese wo hwe yen wutie so Adom FM Asempa FM ena Nhye FM medikan ama wate se mini abema listo wo kwadwofojo ewufie ha sada so na lawyer na na jeba for awia eso ewa homa so lawyer bo ayen amane ekoso ewo court ne munchemu ne ni aka nyina yate Miss Meeting ABY. Lawyer, Miss Amo Akwa Baby. Hello. Ebusian Yesha say and Sabekan lawyer and hello Nana.
Yeah.
Aha, Fede Atom. Lawyer, no watch chin komobia Yesha say they say in Pempenswa yedru and to yam penny for edi egu akwemu any baby yabedru. Lawyer Tsikata ene na this idea ya edikan supplementary statement mpenifo ende we edikan abagu ye tusum yenu application for review no na chese mpenifo gu so a eho achigegie eno aye tatwe ewo honum yenhwe ne asie bontofa ma ye yenkwa anim lawyer
say one say afin an application for interrogatories review of the court's decision or interrogatories afin court etie enonso or can say court no boy bugu you omunsa you and I feel so the lawyers for the respondent electoral commission the president Nana Akufo-Addo can say or make before frobia the application that or argue and say no asabe argue or court to name court no to na sinu say the tendency TM1 no.
Na lawyer utie kasaye ya mpanimfo mi lawyers too yi ede abafa lawyer Tsikata asemo a o kan hu a ne edikan first one no kra no twetwe hu nkomo na so mo kan na besi se wasem na wo kan no emre a wugina so ya wo kan wasem na wo se ya gitumu eho na mo punch holes ne se un state emre bia enu ntie wo se ya gi wasem no tumu baby ayedro eni Supreme Court ho asenka ye no se wunni mra bi a wugina so asema de betudwa bia no aye bola na
say mini aba ade na say the law no aye lawyer ni what ade na sepa just a review no de no et ye no ase ne wasi a cheche review no de sabi nyinko bobio so enti enye akwanya ma wo se wasem aka ne court no bogu ye no eno na wasan de base yensentio there been tisa nemum no oba be kire se there's an exceptional circumstance, there's a fundamental error of law ana bibia se court na nhwe na o man address ya there'll be a miscarriage of justice as a intention kesi bi pa bisi be pa choti ase na eno na unse lawyer for me no first respondent and second respondent lawyers no draw courts na attention say untumi stress ade no so to hear lawyer first respondent lawyer now make reference to the case of Mechanical Lloyd versus Netty so Supreme Court stress a review application there and you ma will be a sebi ya make decision be a when ya anye ho keke o I was so bad no said there has been a miscarriage of justice. There's an exceptional circumstance, a cause of miscarriage of justice. So far, so what it is all when you bua me pacho. What do you say? Mami aminye interview. What do you say?
Hey, now who kura usuro na me? Me ntimi nkwa me lord nti na me de waba no wo de wo kan wunim ni obeka ne ni obeja ni mu ohu
me pacho ne say what you are na say what you are na say eni so bu ba bi gina the wa hwe hu a ohu say Yura Tsikata gina ne na so no his argument was about the relevance of the interrogatories no e ma ni make reference to issues no kra a court ni setting it down. Now, Obekaya, so okay, say time or application for interrogatories in the court no be determined. Na yenru pre-trial conference, okay.
Exactly.
Okay.
Me kai pa lawyer.
Omo can say court no determine and then omo pre-trial settle down issues, no file or witness statement because it be based on the outcome or based on the answers to the interrogatories, no. Omo case no it be omo di beka ho ma ne be asese.
Okay. Omo witness no kura na be ansem omo de beba no benya bi ahihye mu aka ho.
Me ba cho okay. And so say what is say ene iracha Tsikata say ohwe questions are obobisa na ho de toto ensem a ye setting it down for the issues are court no setting it down no wo not just say ama omo interrogatories no akwa hia me patcho here find you setting down issues for trial enya pre-trial no enya pre-trial now so na no omo say ma court no enko
no correct
me patcho ana refi
no correct eno and can no here
until say yisifo no ya interrogatories no okay iti ba cho say na chese se won se bibie ni ada ho enti ade no se ne wote ase ne sa na mete ase
eti nya abotre o de ne wo fra no onya abotre ansa lawyer onya abotre ma ye na ye nhwe lawyer me did say to me to aso ebusia lawyer to office eso bo say de ne ye adwuma teacher say wo de sika ba ko utwa ha no utwa ha na wo ye adwuma kwadwo say lawyer adwuma no den
na me ade ba ko am be say yesia me je say bia obi ho no motifia obebu sasa de ntikura na ye di asem wo Ghana na ya bo asem a ekoso wo Nigeria ni abo asem ekoso wo Togo ni abo ehun hia pa ye wo mresua mu ye fe bibi president
yes
sida ene ne omohwe so ajajefo no hwe so eti se won so ko gina court na se bia ukoka wasem a obetimi obusa se authority ben enyina so ben na ugina so e dia kan wasem it won say
ba ne wu kan sanka ne ye site case bi say ye de ye fato ho a kwadwo na nka ne ya Ghana de se asem wesi wo kwadwo ene akua ntem ebri sei ba we de wu kan no Nigeria ya trash ye ko Nigeria fomra ene ye mra ti se ne o kan obi tifi a se na be chiri mu ho
ye ohwe amamra na constitution no article 11 no e kasafa sources of law be ye mra nyina efiri ba ye mra ni nyina efiri ye common law ye customary ye nananam tetefo ne ade no ene ye equity ni nyina efiri enyiresi it is at the bond of 1844 na usia ya no eno ene ehihye Ghana ne mra ni nyina so enti common law no ejina homa UK fo no sa UK fo ayede omko bata omo no enti Nigeria ka common law countries no enti country bi ya Commonwealth that is British fo di won su bia no
Commonwealth countries
Commonwealth countries no omo nyina omo use Commonwealth common law enti Nigeria common law enti se bi kokosia emra wo Nigeria betima be practice wo Ghana
betina ebre bi admission mokola na se niema amanfo se yenya kwanwuram na bi de omani che African countries bi so
bi Gambia we say your judges be on they go on secondment in Gambia see justice society or Gambia no high court or so Gambia say high court judge or on secondment eti utimi say ye no nyina mra na ye baako and this say ofa emre bi wo Nigeria president bi esi wo na se wo di begina Ghana ha wo de ye fa ntoto ho no ma wana kwan mu ati so enya de ye bone anase enya de a emra ma ho kwan so betimi de no agina na wo de aka wasem no betimi agi atuma na so munyintum nti sa pepepe na etie de se bia wo mte se yabo e bia Nigeria anase bia sem bia si e wo court ye fense
Supreme Court ye o my Ghana mu na
ni nyina omo de tototototo ho se ne be betimi am wasem a wo pese wo kanu edimu ukogina court na sa uko kasembi na se we nya authority and as a president bi enyina so a judge no ahwe akro be pam afri in court wo authority ni se wunyina so ne sen
abusia ye suamra ye mese ye nwie sa court asetene no na ba ko mienu ye te niema ase efa omayi se ne ye mrakuni ye adwuma se ne ya se nibia kese so empanimfo ye wo niema etie fi se ne lawyer ka me ate se ure Supreme Court ho no mo a se ne ye wo niema fa no enye saa na ye no wo other courts ye wo omayimti wura ho a ho nhyehyɛ enko court bia emra ne nhyehyɛ ye ode ye adwuma wo ho no edanso nti yeguso a yesua bi ne ne kwadwo che na kwadwo yenhwɛ enne nsɛm adapono sue no wo se ye de saa application for review ya mpanimfo sere senka enya adwuma ito nkyɛn a na no omusai file for stay of proceedings so eti neidie no se ye wie saa application for review no a ensunsanso ebeba no ena ebe kyerɛ sɛ stay of proceedings ne de ne beba na sɛ emma na sɛ emfa ho ni ne ebesi wo we mu no stay of proceedings ne so de wo sɛ mpanimfo to aso
em say erode ase ne
this a lawyer
ye besi ye trubika esan say omo de enema mienu ne eto we say enena ensem mienu ne stay of proceedings no stay of proceedings no omo stay of proceedings na em say review enti na omo file for stay of proceedings
okay
ne boa enu ntia it is a
eti na say outcome of the review no e won sunsanso of stay of proceedings no so
me gidisa
ma me call lawyer ho no lawyer asan ba humanist lawyer na na ba for area ewo humanist lawyer me da se wasan ababio maka se na osika na ye nufanu betwa ha eti ye boaye ho na question ba ko amacho amaminu abema kwadwo na mihia wo mo wo ansa na yaba ye be kolo ya Tsikata nsem no so na ansa na no unse apart from sa application for review no sa apply for stay of proceedings and then resource be free ruling a bit free sa application for review mo aba no and e be kire say stay of proceedings no so mbe koso ana assessing lawyer me so che mu ho kakrama yen
Pacho some stay of proceedings review ninti no mo file stay of proceedings
okay
and it court ni determine review ni wia not just a stay of proceedings ni dey aye moot and as I redundant assuming for so be
depending on the outcome no
exactly and the court no might not even have to hear
okay
the application
okay me da say wo enchemu a
but in fact no matter the outcome because I see a stay of proceedings pending the determination of the review application it only pends the determination of the review application. It is a court to determine review applications. We are still of proceedings in the Mpachona the 9 as soon as possible.
Ayo, ya lawyer Tsikata asama na no kan ye neso wasensi sudua se ma ye nkase bre ye pentemu nti no ye bema obi kasaboa aka ne yam e wose ye hwe na ensem e wose yetie ne yetie na no kan ye eni amanfo woni ebomu a enne so wasan repeat sa asem no mayenhu ne haw e wo honomo se ebrinti monhwe ne mo antumirika e se waka bibi nne se ye ka se brinti na asenie na ye di tumirika anhwe ya emoa lawyer ho no chemu kakra mayen
epacho on se emrebu no ya na ye pese se be ya ibinya atim prayer any attention in no na e wo se ato yeboye niema so enti na ye ka say don't sacrifice justice on the altar of speedy trial so we say na ye hwehwe so say justice also delayed is also justice denied enti say u delay niam u delay u twentwe wo na ase na maniama so ka akira wo yes anso a Uma nkrofo enya atentene ne ene pepeyo so enti wo se o balance ade ne mienu won se enti na ye wo scale no so there's a balance ne mienu in such a way say obenya atentene ne na mum so obesa nya asem so bia obedi ne ntem na enkotwentwe ne na ase so patcho what I say now enti se o hwe no said yes wo hwe no a no abisa ho se enti se me ma case we so check court said ye wo pese case ne che no me ma case ne che wo court a wo ho me ma case ne che wo court a respondent no so a me do ma ba court no omo so say na omo so no say na ebeye wo mo me pa choti ase enti enye se wo pese wo tena court chenti Now, I said, me chinchina yama ubi so tena court to che. Me patro entisa. You was someone that would me chair court no. Say me wo case. Na case no me yamre. So inti I was a wow case no. Uti just say I was a bibia daddy. E case no say case no. A case bia sebi a sefatamre. Me patro what I say. Na enkoye to say wo na wo pese wo hia mre nti yama wo mre. With the major because say your mouth mera na respondent no so no omonso de bia omonso ba court de bia omonso ba court echo no mo ba no mo ko no omonso no sabi say ensem fata wo the patriot say entu beti obi o say case we makoho court saa enne ye kwa ade ba kwa na judge ne te ho o china na judge ade ba ko no te ho saa wahu entu we de omo say ye betna so nya ye ne se na esi is esese ye no na efata se ye no na asem ye timi adi ama na firi ho eno nchire injustice e pa chote ase eno nchire injustice it is a wo pe justice ampa se court no ma order say file paper we are ese o file so court ma order say ye to anamu we are no why they what to send your open justice no any yourself atase wotena say anaju de suom na wo ye adwuma na ade bibi koto court na numu a na ne waye enti won ka say open time enti e ma o time na afe ne yete ho da